As it pleases the court, good morning, Chief Justice, Deputy Chief Justice, and Justices. I'm Advocate Motabi. I appear on behalf of the appellant in the appeal and confirmation application for the first and second respondents.
Thank you.
As it pleases the court, Deputy Chief Justice, Justices of the court, I appear on behalf of the applicant in the confirmation application and the respondent in the appeal.
Thank you very much.
This is a judgment in two consolidated applications. One for confirmation of an order of constitutional invalidity made by the Labour Court of South Africa, Johannesburg, and another to an appeal against that same order. This case concerns the validity of Section 38(2)B, Roman figure 1 of the Public Service Act that permits the state as an employer to receive monies wrongly paid to its employees directly from their salaries or wages in the absence of any due process or agreement between the parties. It brings into sharp focus issues regarding self-help, an aspect of the rule of law, procedural fairness, and the common law principle of set-off. The Public Servants Association of South Africa, PSA, acting on behalf of one of its members, Mrs. Obugo, sought an interim relief in the Labour Court. It disputed the lawfulness of unilateral salary deductions by the state to recover alleged overpayment of about 794,000 rand. Ms. Obugo previously held the position of clinical manager allied and was transferred in 2010 from the Chief Executive Office at the Tshwane District Hospital to Charlotte Mateke Academic Hospital in Johannesburg. Thereafter, from July 2010 until July 2015, she received the remuneration at the rate applicable to the post of clinical manager, medical. This was a distinct position from clinical manager allied, and it attracted a higher remuneration. In 2015, the state informed Ms. Obugo that she had erroneously received the higher salary. The subsequent deductions to her salary were meant to compensate for past overpayments. Ms. Obugo challenged the deductions as compensation for the overpayment on the ground that if there was overpayment, I beg your pardon, part of the claim for the amount for deduction had prescribed, and that Section 38(2)B, Roman figure 1 of the PS Act was unconstitutional. Initially, the Labour Court issued a rule nisi calling upon the head of the Department of Health, the MEC for Health, the Minister of Public Service and Administration, the MEC for Finance, and the Finance Minister to show cause why it should not grant an order to the effect that all amounts overpaid more than 3 years before the institution of any legal proceedings against Ms. Obugo have prescribed, that the unilateral deductions of monthly installments were ultra vires. Alternatively, that Section 38(2) Roman figure 1 is declared unconstitutional and falls to be read in a manner consistent with the Constitution. Further, alternatively, that the impugned section is declared unconstitutional and to be struck down, and that the head of the department and MEC for Health should pay costs jointly and severally. Pending the outcome of the application, the head of the Department of Health and MEC for Health were interdicted from making any further deductions. On the return date, the applicant pursued the argument that the deductions were ultra-vires the PS Act, that Section 38(2)B Roman figure 1 should be declared unconstitutional, and that the head of the Department of Health and the MEC for Health should be directed to pay costs. The applicant maintained that the impugned section entitled the state to sit on its hand for an extensive period and thereafter recover amounts which would otherwise have prescribed, and that the department should be directed to institute legal proceedings against Ms. Obugo to allow her to challenge the basis of the alleged overpayments. In its opposition, the head of the Department of Health and MEC for Health contended that Ms. Obugo could not claim benefits consonant with a position of clinical manager medical, and that she did not challenge the basis of the overpayment. The Labor Court held that the deductions in terms of Section 38(2)B Roman figure 1 violated the spirit, purport, and object of the Bill of Rights and amounted to untrammeled self-help. Interpreting the provisions based on Section 23(1), Section 25(1), and Section 34 of the Constitution, the Labor Court declared the impugned provisions unconstitutional, but invoked an interpretative remedial mechanism to correct the defects in the impugned provision. The PSA applied to this court for confirmation of the declaration of constitutional invalidity, arguing that Section 38(2)B Roman figure 1 constitutes self-help and violates Sections 9, 23(1), 25(1), and 34 of the Constitution. The head of the Department of Health and MEC for Health, the first and second respondents, opposed the confirmation of the declaration of invalidity and appealed against the order of the Labor Court. The first respondent, I beg your pardon, the first and the second respondent submitted that action taken under the impugned provision is not dispositive of any dispute that the employee is at liberty to pursue the claim in a court or other independent tribunal where applicable, notwithstanding the provision of Section 38. They further submitted that Section 38(2)B Roman figure 1 permitted deductions by way of a set-off at common law. The Department of on behalf of the Minister of Public Service and Administration as a third respondent, also opposed the Labor Court's declaration of invalidity. DPSA contended that the Labor Court did not, in fact, declare Section 38(2)B Roman figure 1 constitutionally invalid. Instead, it argues that the Labor Court found that the provision was capable of an interpretation that is consistent with the Constitution by utilizing the interpretative injunction in Section 39(2) of the Constitution. Therefore, it was argued the correct procedure would have been for the applicant to lodge an appeal with the Labor Appeal Court before approaching this court. Alternatively, DPSA submits that none of the grounds of for constitutional invalidity had been established. It contended that the special mechanism to resolve labor disputes, bargaining councils, arbitration, and the Labor Court do grant sufficient protection to state employees. On the question of remedy, DPSA submitted that if the order of invalidity is confirmed, this court should suspend that order to enable Parliament time to remedy the constitutional defect. A key issue, therefore, for determination is whether the order for constitutional invalidity falls within the ambit of Section 167(5) of the Constitution for confirmation by this court, or whether indeed an interpretative order need to be confirmed. Further, it raises the question of whether the Labour Court has first and foremost jurisdictions to strike down legislation. In a judgment penned by me, concurred by my colleagues, Cameron J., Froneman J., Kampepe J., Madlanga J., Mtlantla J., Mujapilo AJ, Pretorius AJ, and Zondo J, as he then was, majority judgment, we hold that on a purposive and contextual reading of Section 151 and Sections 157(8) of the Labour Relations Act, Section 23(1), 34, 167, and 172 of the Constitution, and Section 15 of the Superior Court Act, the Labour Court was properly conferred jurisdiction to declare the impugned provisions constitutionally invalid. The wider context of the Constitution and the ongoing rationalization processes indicates that denying the Labour Court the power to declare an Act of Parliament invalid when it is specifically vested with jurisdiction to hear constitutional matters would be an absurd interpretation that is to be avoided to effectively vindicate Ms. Obuku's constitutional rights. This court finds that despite the Labour Court's conflating remedies when fashioning its order, the order was in substance a declaration of constitutional invalidity. The proceedings were therefore properly before this court. We conclude that the impugned provisions do not pass constitutional muster, as it constitutes an unfettered self-help, that is, the taking of law by the state into its own hands and enabling it to become the judge of its own case, which violates the legality principles in Section 1C of the Constitution. Further, we hold that the impugned provisions aid self-help, allowing the state to undermine the judicial process as protected under Section 34 of the Constitution. The impugned provision is not only unfair, but it also promotes strict liability on an employee for overpayments, irrespective of whether the employee could pay the arbitrarily determined installments or was afforded an opportunity for legal redress. This court finds that in any event, none of the respondents suggested that a limitation on the Section 34 right was justifiable in an open and democratic society based on human dignity, equality, and freedom. Regarding the argument made that Section 34(2)(b) Roman figure 1 regulates a common law right of set-off, this court finds that the impugned provision is not comparable to the common law right of set-off. The alleged debt was not fully due, as it was not determined pursuant to the application of the rule of law, pursuant to the application of the law in a fair hearing before a court, the doctrine cannot therefore be invoked to defeat employees' ongoing claims relating to their salaries. Given the conflation of the order by the Labor Court, this court finds it necessary to reformulate the order to give Ms. Obugo an effective remedy to obviate self-help and the arbitrary deductions from her salary. We declare the impugned provisions to be inconsistent with the Constitution and invalid. The interim order on deductions from Ms. Obugo's account with effect from 29 September 2016 continues to stand. We will then remit the matter to the Labor Court for resolution of the dispute around the correctness of the recovery of the amount allegedly owed, or rather overpaid, to Ms. Obugo, to be resolved by the application of law in a fair public hearing. The Minister of Public Service will be ordered to pay the cost of the applicant in both the confirmation and the appeal proceedings. I'll make that order in due course. My colleague, Jafta J, has written a separate judgment, the minority judgment, in which he disagrees with the outcome proposed by the majority judgment and the route it followed. In his judgment, Jafta J contends that Section 157, or rather hold the view that Section 1572 of the LRA acknowledges that the Labor Court shares constitutional jurisdiction with the High Court, but however, Section 157.1 seeks to exclude the High Court's jurisdiction in respect of certain matters. He points out that the provision of Section 157.1 reserves jurisdiction exclusively to the Labor Court. The hierarchy of court is established by various provisions of the Constitution, and the proper reading of Section 169.1 reveals that no provision of the Constitution may be read as directly conferring jurisdiction upon the Labor Court or other courts of similar status. Jafta J concludes that Section 157.2 does not authorize the Labor Court to declare an Act of Parliament to be invalid. The judgment finds that, on the contrary, the Labor Court's jurisdiction in this matter was limited to the validity of the administrative decision taken by the state in its capacity as the employer to deduct sums of money from Ms. Obugo's salary if that conduct breached her fundamental rights. Therefore, the minority judgment would have upheld the appeal and declined to confirm the declaration of invalidity made by the Labor Court. In the event, the following order is made. One, it is declared that Section 38(2)(b) Roman figure 1 of the Public Service Act is unconstitutional. 2, the appeal is dismissed. 3, the interim interdict in paragraph 2 of the order of the Labor Court of South Africa, Johannesburg, on 29 September 2016 stands. 4, the matter is remitted to the Labor Court to determine the disputes between the parties regarding the recovery of the amounts allegedly overpaid to Ms. Obugo. 5, the Minister for Public Service and Administration is ordered to pay the costs of the applicant in CCT 6/17 and the respondent in CCT 14/17. I hand the judgment.
Thank you very much, Justice Nkabinde, for the handing down of that very important judgment. We are now entering into another part of this sitting. This is a special session to mark the retirement of Justice Nkabinde from this court. It is an established tradition that when one of the justices of this court retires or reaches the end of his or her term of office, we invite the executive, the legislature, and the legal profession to come and join us in a sitting in open court when we pay tribute to the colleague who is retiring. That is why we have invited all of you to be with us this morning. And on behalf of my colleagues, I wish to extend our appreciation to all of you for having accepted the invitation. In particular, we thank our colleague, Justice Nkabinde, for being with us. We thank her husband, Major General Mone. We thank their children who are here, family members, both on the side of Mutsatsi and on the side of Mone. We are very grateful that they are here. But I take this opportunity to recognize former justices of this court who are also with us. We have Justice Richard Goldstone, we have Justice Albie Sachs, we have Justice Yvonne Mohoro. We are very grateful that you have been able to join us. We are also grateful to the acting president of the SCA and SCA colleagues and other judges who are here. We are also particularly grateful that the chair of the NCOP is here with us, Ms. Thandi Modise. We feel honored that she took time to be with us on this occasion, and I know that it is not the first time that she takes time to be with us when we have a sitting such as this. She represents the legislature. We had also invited the Speaker of the National Assembly. Unfortunately, she could not be with us. As I understand it, she is out of the country, if I'm not mistaken. She has also been here on other occasions when we had sessions such as this. We had invited the executive. Yesterday at dinner, we had the Deputy Minister of Justice and Constitutional Development, Mr. John Jeffries. He apologized and indicated that he would not be able to make it this morning. I'm not aware whether there is any member of the executive that has been asked to stand in for him, but if there is, we acknowledge their presence as well. We also have leaders of the legal profession, both the advocates profession and the attorneys profession, as well as the NPA. We have, for the Advocates for Transformation, Advocate A. Platt SC. We have, for the National Association of Democratic Lawyers, NADEL, Mr. Mvuzo Nochesi. We have, for the General Counsel of the Bar, Advocate C. Watt Pringle SC. We have, for the Law Society of South Africa, Ms. Bayeng Lenyai. We have, for the National Prosecuting Authority, Advocate M.A. Chauke, Director of Public Prosecutions in Gauteng. And of course, there are other members of the legal profession who are also present. Apparently there's been a change in personnel in relation to NADEL, and apparently we have now Mr. Mfana Kwala. Thank you very much. And we have, for the Johannesburg Society of Advocates, Advocate Leah Tabashe SC. Thank you very much. And as I indicated, there are many other members of the legal profession who are attending the session this morning. I will, in terms of the program for this session, make a few remarks, and thereafter we will have the representative of the Advocates for Transformation speaking for 5 minutes, and then the representative of NADEL also speaking for 5 minutes. After that, we will have the representative of the GCB, Mr. Watt Pringle, speaking for 5 minutes. A representative of the Law Society, Ms. Lenyai, 5 minutes. Mr. Chauge for the NPA, 5 minutes. And we will have Ms. Leah Tabashe speaking for 5 minutes. And then we will have the chairperson of the NCOP speaking. I think the tradition is that they speak longer than 5 minutes, and I think it will be 10 minutes. Okay. I have been given another list which has got a representative also of the BLA, Mr. L. Skogo. We are going to, he will also speak for 5 minutes. Thank you. We have gathered this morning to pay tribute to a very special member of this court, Justice Nkabinde, who began her term of office in this court at the beginning of 2006 and her term of office of 12 years comes to an end at the end of December. She has been in this court for 12 years. But her journey has been a long journey. As far as law is concerned, she started her connection with law when she registered at the University of Zululand, Ongoye, in 1980 for the degree of B.Proc, which she completed in 1983. Thereafter, she was employed in the section of the Bophuthatswana government that dealt with the drafting of legislation as a state law advisor. She did her LLB at the University of Northwest, which she completed in 1986. She served her pupillage in Johannesburg. She was admitted as an advocate and practiced in Northwest as an advocate for a number of years. In 1999, she was appointed as a judge of the High Court, Northwest, and in due course, she acted as a judge of the Labor Court, where she acted for 2 terms in separate years. Thereafter, she acted as an acting judge of appeal in the Labor Appeal Court for 3 terms in succession. She was thereafter appointed as an acting judge of appeal in the Supreme Court of Appeal, where she acted for 2 terms. Thereafter, when a post was advertised in this court, she was nominated and appointed to this court. She also served for about 11 years as chairperson of the Rules Board for law courts, which was quite a long term of office. In that capacity, she made a very significant contribution to the reform of some of the rules. She served in that board with, among others, Justice Somyalo, who was Judge President of the Eastern Cape, and during her judicial career, excuse me, she has made a significant contribution to our jurisprudence. She has handed down judgments that have provided benefit to large sections of our society in different branches of law. You have heard this morning, as she was handing down her last judgment as a justice of this court, that she has given a judgment that is not going to help just one person, Ms. Obuku, because the interpretation that she has given to the Constitution, the Labor Relations Act, and Section 38, 2B1 of the Public Service Act, and her conclusion that that provision of the Public Service Act allowing an employer to deduct from an employee's salary monies that the employer believes are owed by the employee without any due process in court and without the employee being able, without the employer being required to prove its case in court, is inconsistent with the Constitution. Many public service workers have suffered under that provision. And this judgment that she has handed down this morning will come as huge relief to many public service workers who will now be able to say, if the employer thinks I owe them, they have no right to help themselves to my salary. They must go to court if we have that dispute and let them prove their case. If they are right, I will pay. If I'm right, I won't pay. This judgment that Justice Nkabinde has handed down is typical of many other judgments that she has handed down. It's interesting for me that the last judgment that she hands down happens to be a labor judgment. And I think, as I've said, many workers employed in the public service will be very grateful to her for this judgment. I know that some of those who will speak will refer to other judgments that she has written over the years, as indeed we had last night at dinner Justice Nkabinde, who paid tribute to her and referred to a number of her judgments. I will therefore only refer to a few that she has written, which for me are some of the judgments for which she will be remembered. In Hassam versus Jacobs NO, which was also referred to yesterday, this court had to deal with the question of polygynous Muslim marriages and the difficulty created by the Interstate Succession Act in relation to women married under such marriage. Justice Nkabinde wrote a judgment in which this court decided that women who are party to polygynous Muslim marriages are discriminated unfairly when the Interstate Succession Act refers to spouse because she held, and this court held, that the word spouse in that section did not include a woman married under a polygynous Muslim marriage. And this meant that such women did not get benefits that other women married under the Marriage Act would normally get. The relevant remedy. And I quote from paragraph 49, having concluded that Section 1 of the Act constitutes an unjustifiable infringement of Section 9(6) of the Constitution, I must now consider an appropriate remedy. The constitutional defect in the impugned provision is manifest. It exists because the word spouse in the Act excludes widows to polygynous Muslim marriages, thus denying them the protection intended for vulnerable women in our society. The dictates of justice and equity require this court to grant an effective remedy which shall vindicate their rights. Section 172(1) of the Constitution requires a court, when deciding a constitutional matter within its power, to declare that any law that is inconsistent with the Constitution is invalid to the extent of its inconsistency. It further provides that a court may make any order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity for any period and on any conditions, to allow the competent authority to correct the defect. And in paragraph 52 and 53, she said, people in the position of the applicant cannot be made to wait to be afforded the protection they are entitled to. The failure to regulate their affairs upon intestacy, as we have seen in this case, does and will continue to have a profoundly detrimental effect on them. This cannot be allowed. As the text stands now, the word spouse is not reasonably capable of being understood to include more than one spouse in the context of a polygynous marriage. The omission of the word spouses is therefore inconsistent with the Constitution, and those words thus need to be added to the Act so as to cure the defect. Accordingly, I would add the words, quote, or spouses, close quotes, after each use of the word spouse in the Act, close quotations. She also wrote a judgment in the case of the governing body of Juma Masjid, which dealt with the question of the right to basic education. When one reads that judgment, it becomes very clear the concern that she and the other justices of this court had about the possibility of education of because the sought to evict the school because the MEC for Education concerned had failed to conclude a tenancy agreement that would have regulated the relationship with property. And throughout the judgment, one can see concern for the basic right to basic education, and to ensure that the dispute was there between the and the land of children. 42 of that judgment, Justice Nkabinde had this to say in 44. The significance of education, in particular basic education, for individual and societal development in our democratic dispensation in the light of the legacy of apartheid cannot be overlooked. The inadequacy of schooling facilities, particularly for many blacks, was entrenched by the formal institution of apartheid after 1948, when segregation, even in education and schools in South Africa, was codified. Today, the lasting effects of the educational segregation of apartheid are discernible in the systemic problems of inadequate facilities and the discrepancy in the level of basic education for the majority of learners. Indeed, basic education is an important socio-economic right directed, among others, at promoting and developing a child's personality, talents, and mental and physical abilities to his or her fullest potential. Basic education also provides a foundation for a child's lifetime learning and work opportunities. To this end, access to school, an important component of the right to a basic education guaranteed to everyone by Section 29(1)(a) of the Constitution, is a necessary condition for the achievement of this right. The importance of the right to a basic education is also foreshadowed by the fact that any failure by a parent to cause a child to attend school renders that parent guilty of an offense and liable on conviction to a fine or imprisonment for a period exceeding 6 months. Furthermore, any person who without just cause prevents a learner who is subject to compulsory attendance from attending school is also guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 6 months. It is against this framework, having regard to the facts of this case, that the question whether the MEC has fulfilled the constitutional mandate must be determined. There is one more judgment of Justice Nkabinde that I would like to refer to, which benefited large sections of our people, and indeed, I would say millions of people in South Africa. It is her judgment in this court in Equity Aviation. It was a labor matter. The main question in the case was whether, when a court or an arbitrator had found that a dismissal was unfair on substantive grounds and had decided that the employee or employees should be reinstated, the reinstatement order is limited to only 12 months in terms of retrospectivity, or whether it can go beyond that period. In other words, if you were dismissed 3 years ago and your case is finalized today, whether your reinstatement can be made to go back to when you were dismissed as a matter of law, the effect of which would be, if done, that you would get your full back pay from the date of your dismissal, as opposed to being awarded only 12 months back pay. This was an issue that had been the subject of much debate in the Labor Court and Labor Appeal Court. Indeed, even prior to 1994, under different legislation, there had been debates about such issues under that legislation. And in a judgment of this court, written by Justice Nkabinde, she held, upon a construction of Section 193 of the Labor Relations Act, that indeed a reinstatement order may be made fully retrospective to the date of dismissal when the court has decided that it would be fair that the reinstatement be fully retrospective. That judgment will help, or has helped, and will continue to help many workers in our country who otherwise might not have been able to be afforded full retrospectivity when their dismissal has been found to have been substantively unfair. As I said, there are many other judgments, and I've no doubt speakers this morning will refer to others. We are grateful to Justice Nkabinde for her contribution. We are grateful to her as our colleague. She has been a wonderful colleague. I have no doubt that I speak on behalf of all my colleagues when I say we are going to miss her. We are going to miss her. I said last night, it's going to be difficult to imagine this place without her, and I would repeat that indeed it will be difficult to imagine this place without her. We will miss her at our meetings. We'll miss her contribution. We'll miss the way she cared for each and every one of us. She would inquire after our families. She would inquire if our children are okay. She is a wonderful person. She has been a wonderful person to all of us and a wonderful colleague. I take this opportunity on behalf of my colleagues and on behalf of the entire judiciary of South Africa to say to you, my sister, thank you very much. You have served this country in a very special way. We are grateful to you. We wish you everything of the best, and we have no doubt that you will keep in touch with us, and we have no doubt that you will continue in different ways to contribute to society as long as you are able to. Thank you. I am now going to invite various speakers. I did indicate earlier on the speakers who will speak. I therefore at this stage invite the representative of the Advocates for Transformation, okay. I'm not going to call the names here because I don't know if it accords with an arrangement that the committee that has been organizing this has made. I'm told that the sequence will be from my right up to the extreme left. Thank you.
Chief Justice, Deputy Chief Justice, and distinguished guests, good morning. One is tasked with delivering a concise speech on a distinguished jurist such as Justice Nkabinde. It is difficult to do justice to the caliber of person she is, because the time I've been given is way too short. I have had the pleasure of working with Justice Nkabinde while she was the chair of the Rules Board. Her leadership during her tenure placed us in a position to interrogate many rules that had far-reaching consequences for the citizens of this country. We at the Rules Board are truly humbled that you chose to lead us for so many years. G.K. Chesterton, in All Things Considered in 1909, said, and I quote, "We do not get good laws to restrain bad people. We get good people to restrain bad laws," unquote. Throughout your tenure on the bench, you have been involved in a number of cases which are a noteworthy contribution to the South African's jurisprudence. One of the most significant cases for me involved Daniel versus Kriobante and another, which is a poignant case involving the issue around land reform. Another one being the occupiers of Urban 87 and 88 Berea versus Christian Frederick de Wet and N.O. This was another case which was a pivotal matter clarifying eviction proceedings. As a woman in our profession, with skewed gender demographics towards men, Justice Nkabinde remains a beacon of hope and an inspiration to all women lawyers, that one day parity of representation of women at the bar and at the bench will be attained. You, Justice Nkabinde, and with other women justices, have carved a path which shines the way for all women lawyers, especially women of color, that it is indeed possible to thrive and make a mark in a profession which is in dire need of diversity and transformation. Your success is one of the many reasons why we, at Advocates for Transformation, will always remain committed to the cause for achieving transformation in the legal field and access to justice. It is our duty to fight the good fight, but this can only be done by emulating your strides and working hard, because as they say, talk is cheap, until the lawyers get involved, of course. Justice Nkabinde, the legal fraternity will forever be indebted to you for your selfless service that you have rendered in the past 18 years as one of the country's finest legal minds. And now, the real work will begin. Thank you.
Thank you very much, Ms. Platt. I omitted a very important part of Justice Nkabinde's judicial career, which I did mention yesterday, an acting stint as Deputy Chief Justice of the Republic from June last year to June this year, and her acting stint as acting Chief Justice for the month of November last year. This was very important. And during that time, she led with great success. And it was history-making. We are very grateful that she led us during that time in those positions. Thank you. We will now have the next speaker for Nadel, Mr. Mfana Gwala.
Thank you, Acting Chief Justice, Justices of the Constitutional Court, members of the judiciary, distinguished guests, ladies and gentlemen. On the occasion of the retirement of the then Chief Justice, late Arthur Charles Carlson, President Thabo Mbeki said, and I quote, "We meet here today to bid farewell to the outgoing Chief Justice, the Honorable Arthur Charles Carlson, and to welcome the new leadership of our judiciary, Chief Justice Pius Langa and Deputy Chief Justice Dikgang Mseneke. We, the people of South Africa, I beg your pardon, in paying tribute to our recently retired Chief Justice, we draw inspiration from the preamble of our Constitution, which states that we, the people of South Africa, respect those who have worked hard to build and develop our country and believe that South Africa belongs to all who live in it, united in our diversity. This holds true for Judge Bess Nkabinde. It is through the appointment of judges of Justice Nkabinde's caliber that this aspect of the preamble of our South African Constitution finds expression. The appointment of Justice Nkabinde was an example of how gender advancement can be achieved by a genuine invitation and a search for capable or those with potential given an opportunity. She joined the bar at one of the smallest divisions, far removed from big commercial and administrative parts of our country. She acquitted herself very well on the Constitutional Court, confounding many skeptics who believed that she was merely filling a quota for black African women. She retires at a very young age. We believe that she will continue to be of service to the country as it is required of all retired judicial officers. The country needs people of her caliber to continue to discharge judicial duties and to associate with other organs of civil society whose objective is to advance the founding values of our Constitution. The National Association of Democratic Lawyers wishes Justice Nkabinde a long and a healthy life and success in her future endeavors. I thank you.
Thank you very much. The two first speakers have been very exemplary in terms of timekeeping. I hope that their precedent will be followed. Thank you.
Honorable Deputy Chief Justice, Honorable Chairperson of the NCOP, Justices of this Honorable Court, present and the former, Justices of the Supreme Court of Appeal, Judges, President, and all members of the judiciary who are with us here today, all our special guests of honor, including our celebrant, Honorable Madam Justice Nkabinde, and her family, members of the profession, ladies and gentlemen, I greet to all of you. Deputy Chief Justice, it is a great honor for me to be afforded this opportunity on behalf of the BLA to join this House in paying tribute and render homage to the Honorable Justice Nkabinde for the role she played in our community, particularly in the judiciary. Deputy Chief Justice, allow me to indicate why it is indeed an honor for the BLA to join you and all distinguished personalities in bidding farewell to Justice Nkabinde when she retires from active service as a judge of the apex court of our country. Justice Nkabinde is the living proof to all of us and the world over that hard work and dedication to the cause of justice is what distinguishes great personalities from the rest. Through her life, we learned that our success is not determined by either our gender or race. We succeed because we are given opportunities. We succeed because we embrace such opportunities and we do our best in order to fulfill them. Justice Nkabinde transited beyond her race and gender, and in her, we see a true meaning of what human race means to us. The prejudices and stigmas which overwhelmed some of her contemporaries did not hold her down. Deputy Chief Justice, this celebration will not be complete if we do not also recognize the role played by this court in bringing about equality among its members. This court is one of the few institutions in this country wherein peers treat each other with respect and oblivious of one another's biological makeup and perceived incapabilities. You see and treat each other as ordinary human beings who are serving this country through dispensing justice to all. It is in this court where its female members have a sense of true equality and belonging. It therefore comes as no surprise to us, as the BLA, Madam Justice Nkabinde, that at your retirement, we see you as an accomplished justice of this country. You defended both our constitution and the integrity of the judiciary. In you, we see a true example of an adjudicator who judges all people before you equally, with justice, the rule of law, and the constitution as the only guiding tools that you use. We observed this, Justice Nkabinde, when you dispense justice and also when you dealt with your colleagues and members of public equally. In your capacity as the acting Deputy Chief Justice and as the chairperson of the Judicial Conduct Committee of the Judicial Service Commission, earlier this year, you handled the inquiry of Judge Jansen with humility but with firmness when you held that, I quote, Judge Jansen's statement suggests that she may harbor certain preconceived biases and potentially at least not to be able to bring an open and impartial mind to bear when determining matters that come before her involving a particular sector of our society, I close quote. This was a difficult decision to make against one's colleague, but because you understood your mandate, you did it. Further, your time on the bench will be remembered for your groundbreaking judgments like Botha and Another versus Rich, NO and others, Masia versus the Director of Public Prosecutions and Another, Lee versus Minister of Correctional Services, 2013. The first two judgments reflect on your consistent approach to justice, irrespective of how diverse the issues in the two cases were. You came up with consistent judgments which show your steadfastness in championing the cause of the disadvantaged, such that you found ways of applying the common law in such a manner that it does not conflict with the Constitution. At times, like in the Masia case, you developed the definition of a common law crime like a rape because development of the definition will increase the extent to which the traditionally vulnerable and disadvantaged group will be protected by and benefit from the law. In demonstrating your identification with what is just in dealing with the vulnerable in the Botha case, you indicated the following. For the same reasons, in this case, forfeiture in circumstances where 3/4 of the purchase price has already been paid will be a disproportionate penalty for the breach. It is because of this type of jurisprudence that you are leaving us with that we will forever be indebted to your contribution in the development of our law. You will be remembered for being part of the judiciary which consistently keep balance between the three arms of the state. You with your colleagues, called upon the executive and the legislature to account to the people of the Republic of South Africa. You vigorously defended the independence of the judiciary. When you take retirement, Justice Nkabinde, you are not going to waste. You are only relieved of the active service in this position, preparing yourself to serve South African society in several other ways. We believe that you will also, in those other positions, continue to champion the cause of the poor of this, and as the defender of the Constitution. We thank you so much for sharing your wisdom with us, and we also, through your well-reasoned judgments, we also thank your family and all your support structures who saw value in educating you and let you contribute in the rebuilding of our society. The Honorable Deputy Chief Justice, I thank you for the opportunity. Thank you.
Thank you very much. Then the representative of the GCB, Mr. Watt Pringle, SC.
Thank you. Acting Chief Justice, Justices of the Constitutional Court, both present and former, members of the judiciary, honored guests, colleagues and friends. It is a singular honor to represent the General Counsel of the Bar at this special occasion on which we say farewell to one of our longest-serving judges and most distinguished members of the Constitutional Court, Justice Bess Nkabinde. As counsel, we are always apprehensive about an appearance in the Constitutional Court. The most stressful part of an advocate's job is the uncertainty of the reaction of the bench to one's carefully crafted and infallible arguments. Infallible, that is, until the grace period ordinarily afforded counsel before there is any intervention from the bench is over. As the questions come raining down, so the argument tends to crumble. Now, the use of the word intervention, note the use of the word intervention and not interruption. Judges do not interrupt. They merely put their difficulties to counsel. Counsel, on the other hand, have been known inadvertently to interrupt judges, on occasion mistaking the latter's thoughtful pauses, sometimes with eyes closed and appearance of lapsing into an early afternoon slumber, as an indication that counsel is again free to speak. It can be a costly mistake. It is therefore a relief to appreciate that I have the floor for an uninterrupted period of 5 minutes or so, but I am no less daunted by the task that lies ahead. The challenge of a task like this is twofold. The first is that I'm not personally acquainted with Justice Nkabinde. The second related challenge is that I prefer not to rely on the internet for my information. Besides, when I typed Justice Bess Nkabinde's name into my Google search, it rendered no less than 24,400 hits in a mere 0.45 seconds. Donald Trump would have been envious of such a result. Mind you, and without wishing to curry favor with the acting Chief Justice, who from counsel's perspective represents the future of the court, the words Ray Zonda rendered 361,000 results in a predictably more ponderous 0.54 seconds. Be that as it may, the thought of sifting through 24,400 hits on the World Wide Web in search of appropriate speech material without the assistance of a competent and uncomplaining junior was simply too daunting. I also wanted to avoid reciting the same passages of jurisprudential eloquence and profundity that my fellow speakers have indeed extracted from the law reports and attributed to Justice Nkabinde as she wended her way from her first acting stint in 1999 via the High Court, the Labour Court, the Labour Appeal Court, the Supreme Court of Appeal, and finally to her present position as a Justice and one-time acting Chief Justice of this court. I therefore discarded technology and went sleuthing in search for raw data, not to be found either on the internet or the law reports. I went to the source of all valuable information, and some may even say wisdom, in the Constitutional Court, the clerks. Since the clerks themselves are the purveyors of such heresy, it must be taken from whence it comes. And having offended the entire court, including the all-important clerks, I may have to consider retiring along with Justice Nkabinde. I managed to track down Justice Nkabinde's first clerk, who served during 2006. It is worth repeating some of her observations of Justice Nkabinde, the person, the judge, and the jurist. As a person, she is invariably regarded as warm and affectionate, caring and thoughtful, as much to her brothers and sisters on the bench as to every member of staff. Her former clerk put it thus: Justice Nkabinde was a caring person in relation both to her matters and the litigants before her, but this compassion was balanced by professionalism and objectivity. She observed that Justice Nkabinde would often say, as she prepared to enter a hearing, that it is fine to discuss one's feelings before the hearing, but they must be left at the door as one enters the court. A second observation was that whilst Justice Nkabinde is able to see the person behind the litigant and empathize even with those who approach the court with an impressive rap sheet, she is a stickler for the application of the law to the facts. The adage that hard cases make bad law has always been well appreciated and applied in the thinking of Justice Nkabinde. A third observation is that she has a reputation for being exceptionally methodical and demanding, insisting that every exposition of law, however appealing it may be to the practiced judicial ear, has to be referenced to an authoritative source. On a personal level, Justice Nkabinde was viewed as the approachable, maternal member of the court who would take an interest in others and lend a sympathetic ear. I can do no better than to quote extracts from an email I received from an international clerk who, far from home, benefited from the singular warmth, generosity, and care of Justice Nkabinde. Funmi Ojetayo wrote as follows: "While I did not clerk for Justice Nkabinde, I was an international clerk for DCJ Moseneke. I did have the singular opportunity of knowing Justice Nkabinde while I was at the court. Indeed, she adopted me as one of her own and made sure to check on me regularly during my term at the court. In fact, she made sure that I was not alone during the holidays and was kind enough to host me at her country home during the Easter break. Fierce in her devotion to the rule of law, tempered by grace as she sought the just result that would most benefit the people, hers is a singular mind, incisive and piercing in her legal reasoning, but it was never intimidating. She was always clear and accessible in her writing. What I remembered, though, beyond her incomparable legal mind, is her sincere and genuine kindness, which came across in how she treated and interacted with not only her colleagues and peers, but those who were her subordinates. She accorded respect, kindness, and dignity to all, from the CJ to the janitor to the homesick clerk." A clerk of more recent vintage, who was not assigned to Justice Nkabinde, spoke on condition of anonymity as follows: "I suspect you may have already heard from other former clerks, but BN was always known in hearings for, 1, being impressively and comprehensively on top of the record, and 2, in the middle of counsel's argument, stopping the proceedings to refer counsel to the most arcane and unexpected reference in the record. The other striking things about my interaction with Justice Nkabinde was that she was always incredibly generous about sharing and reflecting on her experiences as a woman in the profession, both the particular challenges women faced and continue to face, and the pressing need for transformation of the profession. This last observation leads conveniently to the theme on which I would like to conclude my tribute to Justice Nkabinde. I checked the archives of the Johannesburg Bar, where Justice Nkabinde completed pupillage in 1989. Had she joined the Johannesburg Bar at the time, she would have been its 1,175th member since its formation in 1902. She was one of about 31 who completed pupillage and entered the profession, only 4 of whom were black African and only 2 of whom were black women. They included my esteemed colleagues Vincent Maleka, SC, and Khomotso Maroka, SC. By contrast, today there are way more black members of the Johannesburg Bar under 5 years seniority than white members, and women make up approximately 40% of that demographic, the less than 5-year demographic. Despite this, transformation of the profession, perhaps even more so than the bench, presents an ever-increasing challenge. The reason is that whilst the bar has exponentially increased its diversity over the last 2.5 decades, there is growing impatience over the pace at which real transformation is taking place. The position of women in the profession, and of black women in particular, is possibly the most challenging of all, because they suffer the dual disadvantage of racial and gender bias in briefing patterns, to mention but one aspect. That is a topic for another day, but Justice Nkabinde, you are a role model to many aspiring young women at the bar who face some of the same challenges that you would have faced. The fact that you gave up your practice at the bar and devoted nearly 2 decades to public service on the bench and have reached such high judicial office with distinction has served as an inspiration to advocates and to women aspiring to succeed in a world that was, a few years ago, all but closed to women. I thank the court for affording me this opportunity, and I thank Justice Nkabinde for her years of distinguished and selfless service to the bench. I wish you a healthy and active retirement.
Thank you very much, Mr. Wat-Pringle. And now we will have Advocate Leah Kabashe, SC, for the Johannesburg Society of Advocates.
Acting Chief Justice, Justices of the Constitutional Court, past and present, members of the judiciary, colleagues, distinguished guests, good morning. Justice Nkabinde, I rise to pay tribute to you, one of our most distinguished jurists. We at the Johannesburg Society of Advocates proudly claim you as one of our own, surely on the strength of your having spent time with us when you did your pupillage. In his book, The Wretched of the Earth, Frantz Fanon writes, and I quote, "Each generation must, out of relative obscurity, discover its mission, fulfill it, or betray it," close quotes. We at the Johannesburg Bar say with conviction that as a representative of your generation, Justice Nkabinde, you not only discovered your mission as a jurist, but with determination and drive, you made all effort to fulfill it. You have indeed done us proud. Thank you for that. We say these things with conviction, Justice Nkabinde, because over and above speaking to colleagues at the Johannesburg Bar about your influence as a jurist, I took the liberty of reading the rather informative interview you gave to the Constitutional Court Oral History Project in 2011-2012, in which you relate how your mother instilled in you the work ethic that has become the hallmark of your trade. You mention in that discussion that your mother made sure that you could chop wood, cook, slaughter sheep, drive a tractor. She was a woman of substance, just from what you relate in that interview. But more than that, you also relate in that interview that your first exposure to judicial service, though it was indirect, really came from accompanying your father, who was a chief, and had to go to community courts. You would go with him, carry his stool, carry his water, and literally imbibe the ethos, the principles, the values of justice from being with the people he interacted with. From these oral and published sources, Justice, we at the JSA, the Johannesburg Society of Advocates, can respectfully say that you are a jurist of strong character, great dignity, integrity, outstanding intellect, immense humility, and unparalleled resolve. Counsel who have appeared before you have remarked about your temperament, especially the manner in which you maintain a calm disposition, even as you ask the most pertinent questions and debate difficult questions of law with them. That blend of dignity and clarity of thought and purpose has ensured that we, as counsel, respond to this court with the decorum and gravitas that is warranted. With your sisters, more especially those with whom you have interacted quite closely, and I speak here of Justice Mohoro, Justice O'Regan, Justice Rampepe, Justice Mhlanta, Justice Maya, Justice Theron, among others, you have indeed made your mark. You have put women jurists on the map. You've worked at transforming the bench, and you have inspired younger women in our profession to aspire to being you, to being justices of this court. Your contribution to South Africa's constitutional jurisprudence as an individual jurist and as a team player is recorded in numerous cases, particularly those in which you wrote the majority judgment. In those judgments, is a clear record of your sensitivity to issues of racism and inequality, tradition and culture, physical security and integrity, homelessness, infertility and surrogacy, conscience, religion, constitutional obligations and responsibilities. You know, I could go on and on. I here, of course, referred to judgments that have been referred to, especially by the acting Chief Justice. I'll just mention the Prophet judgment, the Messiah judgment, and of course, this morning's judgment. Through these judgments, you have indeed left a legacy that we are proud of. I close, Acting Chief Justice, with a reference again by Frantz Fanon, this time to an extract from the writings of Sekou Touré, who addressed a Congress of Black Writers in Rome in 1959, the year of your birth, Justice Nkabinde. This extract embodies the manner in which you, Justice Nkabinde, have approached the calling to judicial office. Sekou Touré said, and I quote, "To take part in the African Revolution, it is not enough to write a revolutionary song. You must fashion the revolution with the people. And if you fashion it with the people, the songs will come by themselves." He goes on to say, in order to achieve real action, you must yourself be a living part of Africa and of her thought. You must be an element of that popular energy which is entirely called forth for the freeing, the progress, and the happiness of Africa. There is no place outside that fight for the artist or for the intellectual who is not himself concerned with and completely at one with the people in the great battle of Africa and of suffering humanity. I close quotes. Justice, you have engaged in this battle for justice and equality. With your colleagues, you have indeed fashioned interpretive tools that achieve real justice, thereby enabling the populace to realize elements of those songs of freedom which have been muted by circumstance. I thank you, Chief Justice.
Thank you very much, Ms. Kabashe, Ms. Mabayeng Lenyai, for the Law Society of South Africa.
Honorable Chief Justice, members of the judiciary, members of the public, good morning. Thank you for an opportunity to address this forum on behalf of the Law Society in bringing to its constituent members, that is the Provincial Law Society of the Northern Provinces, the Free State Law Society, the Cape Law Society, and the KZN Law Society, BLA and NADER, which comprises 26,000 practicing attorneys and 6,700 attorneys. We would like to say a fair and charming justice. The Constitutional Court, the profession, and the country has had the privilege of the input made into our constitutional jurisprudence by Justice Nkabinde for the past 12 years. Your input has been underpinned by a tapestry of judicial experiences as a judge of the High Court, the Labour Court, the Labour Appeal Court, the Supreme Court, and also your experiences as a law student of the University of Zululand and the University of the Northwest, as a state law advisor, a pupil of the Johannesburg Bar, and as an advocate, but also as a wife, a mother, and most importantly to me, as a Black woman lawyer. In an interview for the Constitutional Court Oral History Project, Justice Nkabinde, you noted that the court is imbued with the wisdom of having diverse voices. There is a need to have such voices, societal voices, so that you can have a rich jurisprudence at the end of the day. Justice Nkabinde, your voice has been such a voice. I would like to touch on a few of your judgments which have contributed to our rich and groundbreaking jurisprudence. In State versus Garcia, that matter dealt with the constitutional validity of the common law definition of rape, and the question that also arose there was whether an individual could be guilty of the crime of rape even though the act was committed prior to the existence of rape as a statutory crime. In an interview, Justice Nkabinde, you mentioned a message, and I open quote, "You people who molest our children, our boys and our girls, you stop it," close quote. The judgment examined the historical perspective of the criminalization of rape so as to determine its developmental direction. In it, Justice Nkabinde, you noted that, I beg your pardon, through the history of the law of rape, it was evident that the object of the criminalization of rape was to protect the economic interests of the father, husband, or guardian of the female survivor of the rape, to perpetuate stereotypes, male dominance, and power to refer to females as objects. You determined that, in accordance with our Constitution and democratic dispensation, based on democratic values of human dignity, equality, and freedom, the social foundations of these rules have disappeared. The focus is on the breach of a more specific right, such as the right to bodily integrity and security of the person, and the right to be protected from degradation and abuse. The crime of rape should therefore be seen in that context. In the matter of Lee versus the Minister of Correctional Services, Justice Nkabinde, in that matter you dealt with the application of the test for factual causation in order to determine liability. You noted in our law and further confirmed, I beg your pardon, you noted that the adoption of a rigid deductive logic in determining causation was not in line with our law, and further confirmed that our law recognized that the test for factual causation should not be applied inflexibly. You further noted that all that is required is the substitution of a hypothetical cause of lawful conduct and the posing of the question as to whether such a hypothesis the plaintiff's laws would have ensued or not. And lastly, in A.B. and another versus Minister of Social Development, Justice Nkabinde, writing on behalf of the majority, found that the requirement of donor gametes within the context of surrogacy indeed served a rational purpose of creating a bond between a child and the commissioning parents or parent. The judgment further indicated that if parents could not contribute the majority substitution of humility and said, open quote, "I think we humble ourselves, we where we are as judges, as role models, as people who shape not only the jurisprudence, who shape our lives as a country, as a people. We have to dispense justice in humility, with respect to the people who appear before us, with respect to the litigants who come before us, and acknowledge where we make mistakes. And I think that will define us better in terms of character, close quote. And in particular to this point, I would like to say something that happened to me, simply because I mentioned your name. I missed a turn because of all the rain and the taxis. And the policeman stopped me because I guess I was harassing other motorists. And they noticed the ropes on the back seat of my car. And they asked me where you are going. And I said, well, today we are going to honor Justice Nkabinde. And because of saying that, and just because of saying that, for the first time in my entire life, I had a motorcade of police driving me here today. And it doesn't end there. I get to the garage, to the parking space. The security guards ask me, ma'am, where are you going? Again, I tell them we are honoring Justice Nkabinde. The gentleman told me to go and sit on the passenger seat, took my car keys, and drove apparently to some VIP parking spot. All because I mentioned your name. It is very important of the people we associate ourselves with. Because if you associate yourself with the right people, you will be treated in a very special way. I thank you very much.
Thank you. Yes, Mr. Chauke.
Honorable Acting Chief Justice Zondo, Justice Nkabinde, and all justices of this honorable court, past and present, the Nkabinde family, members of the judiciary here present, the legal fraternity, members of parliament as represented by Honorable Modise, and the executive, the South African community at large, as well as those present here to witness the occasion of the retirement of Honorable Justice Nkabinde. Please allow me, on behalf of the National Prosecuting Authority of South Africa and the National Director of Public Prosecutions, Advocate Sean Abrams, to express our sincere gratitude to have been invited and requested to pay our tribute to one of the outstanding jurists South Africa has produced. Justice Nkabinde has been recognized the world over for her outstanding work as a jurist. My colleagues in the NPA, and especially those in the Northwest, have great respect and admiration for Justice Nkabinde. The NPA is indebted to the guidance and counsel that Justice Nkabinde has given to us over the years. We will remember her for so many cases that she has presided over. The one case which is outstanding in our minds is a judgment in this court that related to involving the prosecution of prevention of organized crime prosecutions, in which she laid down the foundation and the basis upon which us as the NPA should and should not do in the exercise of our prosecutorial functions in decision-making and the prosecution of criminals. This landmark decision has helped the NPA in making sound and proper prosecutorial decisions regarding the prosecution of racketeering and related matters in terms of poker. We acknowledge a warmth, persuasiveness, and guidance which we have received over the years. We have been humbled and fortunate to be associated with Justice Nkabinde. We have been enriched to do our work without fear, favor, or prejudice, despite some who may hold a contrary view. The NPA is currently under enormous pressure to act in accordance with the Constitution and the rule of law. This we have and still do regardless of the political upheaval and turmoil that has engulfed our society. We are mindful of the surroundings within which we operate. I say so mindful of the fact that within the legal fraternity and society at large may add may think otherwise. It is the duty of all of us to create a fair and balanced approach to the work being done by the NPA. We, of course, welcome criticism. We in the NPA are determined to discharge our role as the protector of the vulnerable in our society without fear, favor, or prejudice. We do not and harbor no ambition to be politicians in the exercise of our prosecutorial work. We salute the tenacity of the judiciary as a whole, and Justice Nkabinde in particular, for the excellent work done for the people of South Africa and the criminal justice system. We will continue to ask for a guidance in our quest to discharge justice in society. We wish her all the best for the future and look forward to cooperate and render assistance in a new stride in her outstanding work as a jurist. May the Almighty guide you, Justice Nkabinde, and your family into the future. We wish you and your family and all present here a Merry Christmas and prosperous New Year. And as indicated yesterday, Justice Nkabinde in the Galadino, the kisses to all and sundry. May God bless you. I thank you.
Thank you very much. Now it is the Honorable Ms. Thandi Modise, Chair of the NCOP. Thank you.
Acting Chief Justice, Justices of the Constitutional Court, past and present, Justices of all the other courts, distinguished guests, ladies and gentlemen. We are meeting here today to say goodbye to Judge Nkabinde. We are meeting to say we honor you, we respect you. We are also meeting to reflect on what justice actually means to some of us. To many of us, when we go to court, you look at the presiding officer and you say, do they hear me? Do they understand me? Do they understand where I come from? Do they understand my language and my culture? Does it make any difference? We were raised in a country that says justice is blind. I've always wondered, if it is blind, how can it feel the pain of those who cannot express for themselves? Justice Nkabinde, we have seen the manner with which you have delivered yourself when you presided. Calm, patient, listening. We have also marveled at the way you have been able to take out that which has troubled us, especially as Black South African women. Issues around polygamous. In fact, you are better off if you're an African woman and you are in a formal polygamous relation. If you are referred to as a partner or a spouse without any formality, your children are the ones that have always given us, as women activists in this country, a problem. And the courts have often not actually understood where we are coming from. I want to say that we admire you, ma'am, because in many instances, you have actually come out to say, I am principled, and I will live by the principles I believe in. Now, in many instances, we do not do that. We sacrifice ourselves, sacrifice what we believe in because we're occupying certain positions. I think, Justice, you will understand what I am referring to. So we celebrate the ability of people who can stand up for what they profess they are. To be honest, to be impatient with bad doing to other fellow human beings. We know that you possess all these traits. We also know that, in particular, your judgments have actually brought a lot of light in the lives of women. Acting Chief Justice, when newspaper reporters retire, they are often presented with dummy front pages in which their departure is a lead story. When a television journalist moves on, the guests at the leaving party are shown a mock news bulletin in which a newsreader introduces the reporter's latest hits. When a judge retires, they often preside over a special validatory hearing, during which they are reminded of those judgments, some of which the judge may not want to remember. The arrangement here today is not really in accordance with this dictate, but that does not mean that Justice Nkabinde may not want to be reminded of some of these. And one of those that we have, all of us across here, been talking to is the Masia case, in which specifically Justice Nkabinde wrote the majority judgment which extended the common law definition of rape to include the non-consensual penetration of male sexual organ into the anus of a female. We know that then Chief Justice Langa wrote a separate judgment in which he went further to include a non-consensual sexual penetration of the anus of either a female or a male. This judgment was criticized by some academics, including C.R. Snyman. But as the legislative arm, this judgment was very progressive. This judgment to South African women, this judgment to those of us who went through rapes when we were young, this judgment began to push us to do more to victims of rape, whether they were female or male. It is why Parliament in 2007 was all in energetic madness to make sure that it passes the criminal law, the Sexual Offences and Related Matters Amendment Act number 32, to expand the definition of rape to include non-consensual penetration of any other part of the body of one person into or beyond the genital organs or anus of any other person. This is one judgment which Justice Nkabinde, you should not forget, because as I said, it brought light to us. It went a little way in dealing with the pains that some of us are still carrying of rape. And it says today that when anybody in South Africa tries and even thinks of penetrating without consent, being given that agreement by the person who must be penetrated or otherwise, that they must think twice. So from the legislature side, ma'am, we can only say, we can only say that you are amongst those women that we hold in high esteem. We say to our young women, our children in the rural areas, if Yvonne Mokgoro, if Bess Nkabinde, if Sisi Mailula, if those women could do it, who says a rural girl cannot stand up and do it? It is important as we go through this country, in the turbulence that we face, that Parliament of South Africa actually comes here and says, thank you, ma'am. It is an unfortunate time for you to leave. And I was reminded this morning that I was one of those who were the first in the legislative sector to complain about judicial overreach into parliamentary issues. But I'm also one of those who has been very, very open about there are matters where we rely on the court to direct. I'm also one of those who say members of parliament are not necessarily lawyers. We rely on the courts to interpret and to lead. We rely in the current circumstances on the courts to remind us as parliamentarians to be proper public representatives on behalf of our people. But we rely on the courts also to be the conscious of us all as a country, to remember that umuntu ngumuntu ngabantu. And I'm saying that, Acting Chief Justice, because every time I look at Judge Bess Nkabinde, ndiyambona laa mntu ungumuntu ngabantu. Awusibhesera leboga. I think it would be foolhardy of the South African women, especially the gender activists, to say it is well and good for Bess Nkabinde to go and retire. I hope we don't let you retire, ma'am. There are many issues that affect women in this country. We have actually, if you have noticed in the last 4 or 5 years, reversed the gains we had made on the forward march of women in this country. There are many issues of children and youth that are coming up. And so I hope we revive a very strong women's voice in this country. And we knock and we knock. Luena Ausivon, we knock at your doors. And we knock at all of you to come back and to make sure that democracy really does serve the majority of the people. Ke a leboga.